Good morning and welcome to another edition of Tobin Talks. Today we're back in the office and it feels really good to be back in the office, and we hope everyone out there is doing well as well. So the last time we talked about the differences between a note and a mortgage, a promissory note and a mortgage, and the implication it can have on two different people. Today we're going to continue somewhat along that line of subtle impacts down the road, and we're going to talk today about real property issues in marital settings. So we're talking about prenups, divorce primarily. So some people don't realize how much real property issues come into play when two people get married or divorced. We all know what a prenup is, but as far as a prenup, it's important to know that your rights, if they are not established in a prenup, go according to Florida statute. So, for instance, in a prenup, if you have a home that you want to keep outside of the marriage in terms of ownership, and it's homestead property, the only way to do that is through a prenup. Meaning that if you own a huge home and then you get married, without a prenup, your spouse will have a homestead interest in that property. You won't be able to sell it or mortgage it without that spouse's signature. So if you don't want that to be the case, you have to have that addressed in a prenup. Additionally, a prenup needs to address issues such as ownership of after-acquired property, waiver of spousal interests, a lot of marital issues that affect all types of property, but can specifically affect real property and specifically homestead. So if you're in that situation, make sure you consult with an attorney about a prenup involving your primary residence. Now, as far as divorce, it's important that you understand your rights and your liabilities, and you should most definitely consult with a divorce attorney or a family law attorney. We don't do that. But oftentimes we're brought in by family attorneys to help address real property issues. So the first issue I want to talk about is both parties being on the note. In addressing how to treat a marital home, if you're both on the note, you should absolutely address that in the divorce. Whose liability will it be? Can you be removed from the note and the mortgage? Whose responsibility will the taxes be? Many times, divorce attorneys don't understand the length and the breadth of issues that can come up with real property in terms of divorce, especially if you own a lot of property together, both homestead and not homestead. There are tax issues that need to be addressed. You don't want to be left holding the bag on those issues. You really should bring in a real property attorney and an accountant, and not just leave it up to the divorce attorney, who may or may not be so well versed on those issues. So when it comes to a marriage or a divorce, if there's something unique about real property, address it before the marriage or address it in the divorce proceedings. A lot of real property issues get messed up by not being properly addressed in those family law papers, and it's hell to pay down the road if you don't address it right. So those are some of the real property considerations in marital settings. As always, feel free to call us with questions. We love hearing from you, and if you listen to this entire video, then by God's sake, you should subscribe to our Tobin Talks. Thanks again, and best wishes to you.